It's really not hard to be a popular politician. All you need to do is not rock the boat. All you need to do is not change anything, spend all your time kissing babies and cutting ribbons. But what is the point in that? That is not why we were elected. We all came here to serve our fellow citizens, to make our state a better place to live, to thrive, to achieve the American dream. Some of us have different perspectives on how we reach that goal. Now I want to highlight the three things of great importance in this session as we begin this legislative session. There's a nationwide push by the far left to weaken the First Amendment to the Constitution. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech. We either believe in religious liberty or we don't. In Louisiana, I believe that we do. I know there has been legislation filed this session that aims to protect religious liberty rights right here in Louisiana. And let me be crystal clear. I absolutely intend to fight for the passage of this legislation and any other that seeks to preserve our most fundamental freedoms. But let me also be clear about something else. In Louisiana, we do not support discrimination, and we do support religious liberty. And we believe that we can uphold both of these values simultaneously. But the truth is, this should not be a conservative versus liberal debate. Last I checked, we were all in favor of the Bill of Rights. And here in Louisiana, as long as I'm your governor, we will protect religious liberty, and we will not apologize for doing that. I want to directly address the legislation that was filed to protect those freedoms in Louisiana. Let's clear up some falsehoods about the bill that we've already started to hear. All this bill does is provide necessary protections for individuals to prevent adverse treatment from the state based on religious beliefs regarding marriage. This legislation does not allow a restaurant or industry to refuse service to a gay or a lesbian person. The law merely ensures the state cannot deny a license, certification, accreditation, or contracts to a person or a business on the basis of their sincerely held religious beliefs about marriage. It does not provide a right for a business owner to discriminate against gays or lesbians. I think we can all agree that the government should never force someone to participate in a marriage ceremony against their will. People, charities, and family-owned businesses should not be penalized because they believe in the traditional definition of marriage. Now, regardless of your beliefs about the definition of marriage, we should all respect the right of our neighbors to hold a different view. There used to be bipartisan support for the principle of religious liberty. However, these days, some think diversity of belief is too risky, too scary to be tolerated. But that's wrong. In America, we should celebrate diversity of belief. Diversity of belief and religious liberty are the foundation of our law and Constitution, and they must be protected. In the United States, a state should not be able to take adverse action against an individual for holding a sincerely held religious view regarding marriage. Now that would be true discrimination.
Let's start with Representative Johnson on House Bill 707.
Thank you, Mr. Chairman. Members, a lot has been said about House Bill 707, as you know, and unfortunately, a lot of what has been said is inaccurate. There's a number of amendments that you have before you, and if it pleases the committee and Mr. Chairman, I'd like to present those first and put the bill in the proper posture for consideration.
Representative Johnson, why don't we do this, because I know that we have a lot of cards in support and we have a lot of cards in opposition. The amendments are amendments that were made public and delivered to the committee as well yesterday. I'm not sure anybody yet knows exactly what they do and would like an explanation. So sure. Why don't you describe either the bill or your bill as you would propose amending it, and we'll take up the amendments in due course, but why don't we go ahead and get your explanation of what the amendments do.
Great. The amendments you have before you are pretty simple. There's a number of technical changes, which is usual. The substantive changes to the original bill that was filed and that has been online for a few weeks are these. That would be amendment number 2, where we have added to the beginning of the bill, we modified it in this way. We've said that we're going to define marriage as our Constitution does, as the union of one man and one woman. The reason we put it there in the amendment in the beginning of the bill is because some folks were, I think, exploiting the letter and the spirit of the bill, and so that eliminates that possibility. The other substantive amendment would be Amendment number 4, which I draw your attention to, and it strikes a couple of provisions on pages 2 and 3 of the original bill. Those provisions merely were inserted in the original draft to make reference to existing federal qualifications for employee benefit plans. They were deleted because the reference was unnecessary and it was seeming to cause some confusion on behalf of some folks. So as a good faith measure, we just struck it out of the bill. The only other real substantive change, I think, is that I draw your attention to is Amendment number 13 on the second page of the amendments there. And this one I think is very important because we added this very explicit language, express language in the bill that says, nothing in this part shall be construed to create any right of discrimination between private persons. We felt that was important to put in there to clarify what the bill is about, what it does and what it does not. So that's the amendments by way of quick explanation. I'd like to tell you about the bill overall, if that's appropriate.
Yes. Why don't we do this? Why don't you give your presentation of as the bill as a overall, and as you propose the committee consider amendments at due point at some point. We'll have the rest of the speakers in support come and speak. We'll have the opponents because they may want to address the amendments before the committee takes it up, and we'll kind of follow that process. So,
sure.
Representative Johnson, please continue on your bill.
Thank you, Mr. Chairman. The Louisiana Marriage and Conscience Act is what we've entitled this under House Bill 707. It's designed to codify legal protections for those who have a moral and religious conviction about the nature of marriage as between one man and one woman. In spite of its many mischaracterizations, the bill really just does one simple thing. It would protect these people from government discrimination by the state government exclusively, and preserve our state's commitment to the fundamental freedoms of conscience and religion. House Bill 707 has been called by some of the top legal scholars in the country as timely, necessary, and well justified. And people say, why is it so timely? Why is the time now? Well, all of you know, because we've talked about it and you've seen it in the media, April 28th was the big oral argument at the U.S. Supreme Court on the same-sex marriage cases that will decide the fate of marriage for the whole country. We expect the opinion to be handed down June 18th. It was at oral argument that there was some dialogue there amongst the justices and amongst the Solicitor General of the United States, Donald Verrilli, about this very question. And the dialogue got a lot of attention nationwide. I refer to it as seismic in constitutional law circles, which is where I've spent my career. But this was just one exchange in an excerpt. This is on page 38 of the transcript of that oral argument. Justice Alito is asking the Solicitor General of the United States, he says, hypothetically, what if you win? What if same-sex marriage is declared the law of the land? Let's say we declare it a fundamental right. The court agrees with you. And he says, will the tax-exempt status of a university or a college be in jeopardy if it opposes same-sex marriage? General Verrilli says the following, quote, it's certainly going to be an issue. I don't deny that. I don't deny that, Justice Alito. It is going to be an issue, unquote. Elsewhere in the oral argument, Chief Justice Roberts asked the Solicitor General a follow-up question. He says, we have a concession from your co-counsel just a moment ago that clergy will not be required to perform same-sex marriage, but there are going to be harder questions. Would a religious school that has married housing be required to afford such housing to same-sex couples? General Verrilli answers the following. He says that is going to depend on how states work out the balance between their civil rights laws and how they decide what kinds of accommodations they're going to allow under state law. And they could, well, different states could strike different balances. Chief Justice Roberts replies, well, what about federal? If it's a federal question, it's a federal question if we make it a matter of constitutional law. General Verrilli responds, but the question of how states use their enforcement power is up to the states. So that exchange, that dialogue, illustrates vividly the need for this legislation. Every state is going to have to take up a bill like 707, and they have to do it now because this is an imminent matter. The decision comes down June 18th. We're going to have this inherent conflict. According to the Solicitor General, then, of the United States, it's a fact that at least religious institutions are likely to face discrimination in this era of marriage redefinition. And in this environment, we need a piece of legislation like the Marriage and Conscience Act. HB 707 is very narrow in its scope. One law professor described it this way. He said, quote, Since the founding of our nation, Americans have always enjoyed the liberty to act in the public square on the basis of their moral and religious convictions that marriage is the union of a man and a woman. The freedom of conscience and action has always extended to all aspects of public life. By comparison, the Marriage and Conscience Act in Louisiana would prohibit only state action, quoting from the bill, against a person, wholly or partially, on the basis that such person acts in accordance with a sincerely held religious belief or moral conviction that marriage is or should be recognized as a union of one man and one woman. It does not apply to rights and duties in private law. That's an important distinction. And it does not even apply to all state actions. It enumerates, as you can see in the bill, just 4 discrete categories of action that we would prohibit. Under the bill, the state of Louisiana could not, number 1, deny or revoke an exemption from taxation if a person stands on or acts upon their belief in traditional marriage. Number 2, disallow a deduction for state tax purposes of any charitable contribution made to or by such person. Number 3, deny or exclude such person from receiving any state grant, contract, loan, license, certification, accreditation, employment, or other similar status. And number 4, deny or withhold from such person any benefit under a state benefit program. That's it. That's all the bill does. In other words, all we're saying here, as I've tried to explain it to people, to put it in layman's terms, is that a person cannot be given the equivalent of the death penalty in the marketplace in their profession or their business just for standing by a sincerely held religious belief about the definition of marriage that's been in existence for more than 5,000 years. There are a number of claims that have been made about what the bill would do and all of that, and I can address those in questions if they come up. But I would summarize the bill and what this is about and what we're trying to do pretty simply. This bill provides our state an important opportunity to model tolerance. This is about encouraging a respectful, diverse society where citizens from all viewpoints can peacefully coexist. Everybody in our society deserves dignity and respect, everyone. But part of that is upholding the right of people to adhere to their faith. Regardless of our individual beliefs about the definition of marriage, every citizen should respect the right of our neighbors to hold a different view, and all of us should agree that we don't want the government to be allowed to discriminate against us or our neighbors simply because of what we believe. This act will preserve the most fundamental of all human rights, and that's the right of conscience and the freedom of belief. We in Louisiana believe that the state should never be allowed to coerce you against your most sincerely held religious conviction, and that's an important thing to protect. I can say a number of other things about it, but in the interest of time, I know that we have a lot of testimony to hear, Mr. Chairman. So,
Thank you, Representative Johnson. Mr. Evans, do you have any additional comments?
Thank you, sir. Good morning, Mr. Chairman, members. My name is Rick Edmonds. I'm the Vice President of Louisiana Family Forum. I'm also a 39-year Southern Baptist pastor. And along with my testimony today, Mr. Chairman, I have a letter from Dr. David Hankins, who's the Executive Director of Louisiana Baptist Convention. And we know he's en route, but not here. But I'd like to present this to the committee as well. Only read a segment of it.
Dr. Hankins is here.
Oh,
Okay, we're gonna bring up Dr. Hankins next.
apology. Thank you. I did not know he was in the room. Thank you very much. Some would say, why this bill? We already have some level of protection. Some would say, why? There are more important issues to deal with in this legislative session. Some would say, wait, the Supreme Court of the United States will issue a ruling this summer. I suppose one could frame an argument in a variety of different ways and never get it all said. So I begin with the latest story to establish the environment we're in. Reported Monday, May 18, 2015, the headline reads, Ruth Bader Ginsburg officiates another same-sex wedding, gives a special shout-out to the United States Constitution. Supreme Court Justice Ruth Bader Ginsburg officiated a same-sex wedding over the weekend, and according to the New York Times columnist Maureen Dowd, the notorious RBG gave a big shout-out to the United States Constitution. Dowd wrote Ginsburg's officiation may have held deeper meaning than pronouncing the two grooms married, but the most glittering moment for the crowd came during the ceremony. With a sly look and a special emphasis on the word Constitution, Justice Ginsburg said she was pronouncing the two men married by the powers vested in her by the Constitution of the United States. This story further illustrates the conditions that we as a nation and as a state are now facing. Not only would a Supreme Court justice refuse to recuse herself, She would flaunt her position to the nation on the one hand and defame the sanctity of her office on the other. We're facing a court that could, in a handful of days, rewrite and dismantle the definition of marriage that, as Justice Kennedy described, has been around in millennia. The goods and bads of democracy will not be tested. The democratic process could be discarded by 9 judges that could do what no group or nation has done in all of human history. The traditional view of marriage or definition of marriage, one man and one woman, could be eliminated, regardless of the views of Christians and Muslims and Jews, history or tradition, with one simple vote. No voice of the people, no votes from Congress or state legislators, no constitutional amendments. Surely no rational thinkers could possibly believe that all of American history, better yet, all of human history, has gotten this issue wrong. All pastors, priests, rabbis, leaders, congressmen and women, presidents, governors, senators, founding fathers, church fathers, some of the most generous and loving people to have ever lived, all missed on this definition. Yet that's exactly what has arrived. So what is one to do? That brings one to HB 707. And the truth is, religious freedom is under the greatest attack in American history. You see, we pastors have led our churches to believe the Holy Bible and is our book that we follow, period. The book is what shapes our lives. It's where our values come from. Our morality is shaped there. Critical sacraments and definitions flow from its pages. One of the most critical and sacred unions of that is marriage, and marriage is defined between one man and one woman. Yes, there's many times that man does not get it right on this issue, and many others. Yet the view remains the same, and man is left with these deep-seated traditions that do not change. They do not adjust. They do not evolve. It's not because of hatred or intolerance or lack of love or respect. It's not to eliminate choice from people or infringe on one's happiness. It's what we believe. Nothing more, nothing less. Like many others, I'm not angry with anyone. It's not my desire that some should be punished or damaged or discriminated against. In fact, my opinion is of very little value. One can ask, what has God spoken on this matter? The simple answer is yes. Male and female, He created them. So we're asking for protection today. Someone has rightfully said HB 707 is not a sword, but a shield of protection. We're asking, as some would say, for some outlandish definition or protection from our beliefs. That's not it. We're not asking that people should lose their jobs, not be served in restaurants, people lose their benefit. The bill doesn't ask for any of these things anyway. We're asking for freedom. I have a cardiologist friend that puts it this way. If you're having issues with your heart, one does a stress test. If blocks or plaque or things are involved, a quality physician will look for every preventative course of action. Diet, exercise, medication, etc., anything to avoid the knife. Yes, he can predict and remedy certain problems with bypass surgery, valve replacement, and the like, but he would prefer prevention. Before any more damage can be done, let us use an ounce of prevention. Let's protect our marriages in Louisiana. Let's protect our religious freedom. Let's set the standard for our nation and pronounce that religious freedom is still alive in America. Mr. Chairman and members, I ask for the favorable passage of HB 707 and its amendments as presented this morning. Thank you very much.
Thank you for coming. Thank you for testifying. Gentlemen, I appreciate your testimony.
Thank you, Mr. Chairman. We heard a lot of impassioned testimony today, and we heard from a lot of great Louisianians, and I do personally respect all the folks who sat here today, and I love that we had a civil discourse. It's important to our system. I know all of you agree, and so I commend everybody for taking the time to come out. This is what democracy is all about. Just a couple of things in sort of, I guess, rebuttal. There were a lot of claims made about discrimination and supposed economic impact of a bill like House Bill 707. The characterizations range from inaccurate to some of them I just think sort of wildly outrageous. The bill, as amended, as we said here in the beginning, says expressly, nothing in this part shall be construed to create any right of discrimination between private persons. There was a lot of talk about how this might have a $40 million loss to the general fund. I mean, there's nothing to substantiate that number. This is not Indiana and Arkansas. What you all know is what happened in Indiana and Arkansas is they were trying to enhance a RFRA, which we did 5 years ago, to sort of govern private business transactions. That is not what 707 is about. And so this is not that same dispute. And when people realize that, they recognize it. That's why you haven't had more businesses come and say they're going to boycott, because this doesn't have anything to do with discrimination. The opponents called this state-sanctioned bigotry, but they ignore the plain language of the bill. It says it right on its face. 500 businesses and over 1,600 individuals have signed a petition enthusiastically in favor of House Bill 707 at la4liberty.com. They just started that petition about 3 or 4 days ago. There'll be more. Those are going to be presented to you shortly. You had, I think, 123 green cards today, many people representing many others who couldn't be here. You know how this goes. There are people on all sides. You did see the polling data that was interesting, came out yesterday. 500 likely voters around the state, 4% margin of error. They determined that 67% of Louisianians support the language of the bill, the actual language of the bill, when it's read to them. So we've got 2/3 of the state across all demographics who say, yeah, we believe protecting religious freedom is important. It's not about treating anyone unfairly or in a discriminatory manner. That's not what we're about. A couple of things that were said here are just wildly inaccurate. One of them, the ADL letter, for example, says that if the bill passes, any couple, whether they're same-sex, interfaith, interracial, could be denied services. It's just simply not true. If you read the language of the bill itself, it says, Amendment number 2 at the top, a sincerely held religious belief or moral conviction that marriage is or should be recognized as a union of one man or one woman. So it eliminates all the other potential abuses and all the sort of the parade of horribles that was said. One of the questions asked is, why isn't our RFRA enough? What about the First Amendment? We already have the free exercise of religion. Y'all know I've been defending the free exercise of religion, the First Amendment cases in the courts for almost 17 years. The reason is, here's the simple answer. The First Amendment, the Federal Religious Freedom Act, Religious Freedom Restoration Act, the companion statutes, the Religious Land Use and Institutionalized Persons Act, our state RFRA that we passed 5 years ago, other legal protections about our first freedom, religious liberty, don't establish conclusive rights in this arena. So they don't establish a conclusive right to act or refrain from acting on the basis of one's conviction that marriage has a particular nature. Conscience protection, as you know, when you go to the RFRA thing, it's a balance. So conscience protection depends on the discretion of lawyers and judges who define the interest implicated in any dispute between a conscience claim and a sexual identity claim. And they balance those interests against each other. And as you know, if you follow this in recent months, the balance has come out against conscience claims in nearly all cases. So religious observers need this basic protection. All we're saying, after everything that's been said, all 707 does is one simple thing. It simply removes these 4 discrete categories of ultimate harsh penalties that might be imposed upon someone if they stand for their view of marriage, their religious or moral view. All it's talking about, as you see in the bill on its face, we're talking about accreditation, licensing, certification, tax-exempt status. And if we look to the language of the Solicitor General of the United States just a few weeks ago, they said this is going to be an issue, and every state is going to have to look into this and figure out how to balance it. So this is our opportunity to do it. I know I'm sure there'll be questions, and I'm happy to answer those. Should I take those first, Mr. Chairman? And then
Yeah, let's go ahead and do that. Representative Edwards.
Thank you, Mr. Chairman. And Mike, I want to thank you for the conversation that we've had today. And I know that it's sincere. You and I have had opportunities to discuss this throughout, including before the session ever started. And I appreciate your willingness to spend some time with me. And I know that you're sincere. I've known you since, 20 years or so now. And really appreciate your work. I do have some concerns, however, and I want to talk to you about them. You started off talking about, I think it was some testimony at the U.S. Supreme Court dealing with churches and hospitals and universities, religious institutions. And as a lawyer, I can't understand how we can do anything in your bill that isn't already protected to the maximum extent possible, both with respect to the state constitution and with respect to the 2010 Preservation of Religious Freedom Act, which creates the strict scrutiny standard, which, as you know, is the highest standard we can give to protect a right. Compelling governmental interest, least restrictive means. And so I'm at a loss for how the bill strengthens that right at all. And in fact, because the bill includes Moral conviction, which is not part of the First Amendment and is undefined in the law as best I can tell. I'm not sure that you aren't inadvertently creating problems for what we did in 2010.
Good questions. Here's the answers. Let me take them in reverse order. On the moral conviction, the reason we included that language there is so that because some people have a conviction about marriage as between one man and one woman, as it's clearly defined in the bill itself, that's not based on a religious conviction. They have a moral conviction. They may say they're an atheist or a secular humanist or what have you. That's everybody's right. They can believe whatever they want. If they believe that marriage is, as we say here, is or should be recognized as the union of one man, one woman, whether it's based on their moral conviction or their religious conviction, the state doesn't take a side in that, doesn't say one is more valuable than the other. That's the reason the language is included. With regard to the RFRA protection, as I said just a minute ago, everywhere, there's 21 states now that have RFRAs. When these balances have been taken up by the courts, they've ruled against those claiming the RFRA defense. And they've said that even though you're applying strict scrutiny, it's not enough, because sexual identity is balanced against religious freedom, which is the reason the Solicitor General said just in oral argument a couple of weeks ago, he said, listen, everybody recognizes we're kind of moving into new territory in the United States. We haven't been here before. And regardless of where everybody is on this issue, everybody's entitled to their own right to live however they want. But part of that is we've got to balance respecting one another's views. And the problem is, without having these types of protections, as the Solicitor General said, without each state figuring out how they're going to balance these things, it's okay to take the death penalty for the marketplace off the table. That's what the bill does. I keep saying that because that's the easiest way to explain it. All we're saying is municipalities, companies, they may come up with ordinances and policies to deal with this issue, and all those things will be balanced and figured out in the courts over the coming years. In the intervening time, though, the state, just the state, can't put you out of business because you tried to stand for your religious belief. That's all it does.
Yeah, well, I think it does a little more than that, but I mean, I heard what you just said. It's hard for me to understand how this bill does anything to protect what you're seeking to protect that isn't already protected to the maximum degree possible in the state constitution and in the 2010 act that you just mentioned. And obviously, we have to vote on what we believe the bill will do or not do based upon the language in the bill, and not upon testimony either in support or in opposition to it. And I would just ask about a few things, because I think the implications of the bill are more far-ranging than maybe you believe them to be. For example, it doesn't just apply to people's rights to not participate in a ceremony or in a celebration, because we've had a lot of people say, well, I shouldn't have to bake a cake if I don't want to, or rent a tuxedo, or provide a floral arrangements, or have my band perform at a reception.
The wedding industry.
Right. But this is not just that, is it? I mean, this is more than that.
It is, because this would be, for example, a Christian college, as they were talking about at the U.S. Supreme Court. If a Christian school, let's say Louisiana College in Pineville, Louisiana, 109-year-old Baptist institution, marriage student housing, they have a policy that says we're only going to allow opposite-sex married couples to live in housing. All this would say is Louisiana College can abide by that policy, and the state's not going to meddle with their accreditation just because they abide by that policy.
Yeah, but that gets back to the point I made earlier. I believe in that situation it already has the maximum protection that the state can give it through the Constitution and through, but it also does some other things. Let's take, for example, a teacher who decides that he or she does not want to meet with the parents of a child in that classroom because the parents are married and they're gay. It seems to me that this bill would say that teacher gets to keep teaching, and there's nothing that the state can do to require that teacher to meet with those parents.
Great question. Here's the answer. The state would not be able to, if the bill passes, the state would not be able to kick the teacher out of her profession for that. That's true. They would not be able to pull her certification to teach, okay? However, at the school level, whatever the school's policies are, whatever the local municipality's ordinances are, all those other restrictions and provisions would apply. All this says is the State Department of Ed is not going to give her the death penalty in her profession because she has that conviction. Now,
But
we
have
might agree that's
teachers-
absurd that she would do that, but that would be taken care of at a local level where it should be
But
by the
not
school
in all
board.
cases, because we have some teachers who work directly for the state.
Yeah, yeah.
And so if the bill says the state cannot do anything with respect to the employment or certification of that teacher.
That's right. They still could discipline the teacher in any number of ways. They just could not pull her certification.
And that teacher has to remain employed under this bill.
She does, right.
Right.
But she could be suspended, she could be fined, she could be sanctioned in any number of ways that the state would decide.
Yeah, except that employed, I think it means that they get paid.
Right.
They're going to continue to hold a position, even if they, after being told, no, you've got to go meet with these parents, and they persist in refusing to do that, they have to remain employed.
Yeah,
And
that's
so
right.
I think the bill does more than you suggest. The other thing is, it actually has implications beyond that as well. Let's say that you've got a doctor who is working in an emergency room for the state and either has a contract with the state or is a direct employee, and they decide that they're not going to provide treatment. The state is powerless to make that doctor provide that treatment under this bill because it's with respect to being licensed and employment. And so I think the bill goes far beyond.
Let me answer that though. If an emergency room physician denies service to someone, they'll be in violation of a number of federal laws and other laws that apply. So EMTALA, the Federal Emergency Medical Treatment Act, requires them to provide medical service. If they didn't, they would be sued for malpractice. if
EMTALA
someone got hurt.
requires that the hospital provide it, not a
Right.
particular doctor.
That's right.
And the doctor could refuse. And even as I read the bill, even if that results in harm to the patient and the doctor is sued, the state still has to make available the limitations under the Malpractice Act because that's a benefit of employment.
Yeah, it is.
And so the state would actually have to maintain that. And so,
But the cap applies to everybody across the board, right? The Malpractice Act applies to everyone.
yeah, but if someone is harmed from a refusal to provide service,
They have a great malpractice action, and there'll be a bunch of lawyers that'll take their case.
except that they get the benefit of the limitation of liability.
They won't get their license pulled to practice medicine, but everything else can happen to them under the sun, as it should.
Well, but they don't if they're employed by the state. They don't have any personal exposure there.
Not by the state. Under this bill, the state wouldn't be able to pull their medical license, but everything else is available. They have private action.
The state wouldn't be able to fire them either because they have to remain employed.
That's right. But the malpractice action and all of the other legal remedies would take care of that.
What do you mean take care of it?
I mean, if someone was harmed because a physician was obstinate and refused treatment in an emergency situation, they would have a fantastic malpractice action and they would go after the guy. His insurer would cover him up to the limit, and then the Medical Malpractice Act, the caps would go into
in the
place.
case I'm talking about, his insurer is the state of Louisiana.
Yeah,
His employer is the state of Louisiana.
right. They'd have to provide the insurance coverage.
And,
That's right.
and the employer wouldn't be allowed to terminate his services on that basis.
That's right. You
And,
work
and
for a
would
state-
have to afford the limitation of liability and the protections. I guess what I'm trying to show you is that I read the bill. It's much broader in its application than the very limited scope that you say you intend.
Well, and I've just answered every hypothetical and told you that's not true.
You didn't answer it to my satisfaction.
All right, Judge. Okay,
And-
Judge Edwards,
Well, I mean, you can call me a judge. I don't know.
Governor, whatever you want. Okay,
Well, no,
all right.
I just John Bell would be fine.
John Bell.
Okay. I just can't read the bill and conform it to your stated intention.
I got you.
And I have no doubt, or I guess no reason to believe that you're not sincere. I just don't believe you're correct.
And I'd say the same of you, and I appreciate you.
Thank you.
Thank you, Representative Edwards. I want to take up your motion to amend. I want to offer up a substitute motion to go ahead and return your bill to the calendar of the committee at this time. So, members, before the committee is my substitute motion to return the bill to the calendar. Is there any objection?
I'll object.
To which Representative Johnson objects. Madam Secretary, would you call the roll? And let me make clear, members, you're voting to return the bill to the calendar. This is not a vote on the merits or the substance of the bill or the amendments at this time. Madam Secretary, please call the roll.
Representative Abramson?
Yes.
Yes. Representative Landry?
Yes.
Yes. Representative Bowie?
Yes.
Yes. Representative Edwards? Yes. Representative Gaines? Yes. Representative Garofalo?
No.
No. Representative Huval?
Yes.
Yes. Representative Jefferson? Yes. Representative Johnson?
No.
No. Representative Miller? Yes. Representative Shake Snyder? Yes. Representative Williams? Yes. I have 10 yeas, 2 nays.
Thank you, Madam Secretary. The bill will be returned to the calendar. Thank
Thank
you,
you, Mr.
Representative Johnson.
Thanks to everybody.
Senator Peterson on appointed personal privilege.
Thank you, Mr. President, members. Members, on behalf of the folks not only in Senate District 5, but the people all across this state, I rise to just offer some commentary on the last probably 3 hours of activity from somebody on the 4th floor. I don't know if he's there. My district includes some of Louisiana's most important tourism and business assets: the Superdome, the Convention Center, the CBD, the Port of New Orleans, and much, much more. The Historic Garden District, I can go on. Governor Jindal's marriage-conscious executive action that he's planning to take is in direct contravention to the will of this legislature. That bill, which failed by a vote of 10-2, focused on helping to legalize discrimination in the name of religious belief and under the guise of religion. It's a cynical attempt to deflect from the failures of what should be the top legislative priority, what we're dealing with every day, which is a broken state budget. Today, the legislators rejected House Bill 707 in committee by a vote of 10-2. It was a clear rejection. And he said that was a top legislative priority for this session. And after this humiliating defeat today, he now wants to circumvent the legislative process. Now, we've heard him talk about how he feels about executive orders, though those are at the federal level. He don't like those. But today it's okay to just ignore the House in a clear rejection of something that's just not good for our state. He didn't even have the courage to testify before the House, but he wants to roll out a press release saying what he's going to do through executive action. But guess what he did have time to do? To start running a commercial, not here in New Orleans or Baton Rouge or Monroe. He ran a commercial on religious freedom in Iowa. Are you kidding me? Why don't you roll some commercials out on how to fix this nightmare that you've created right here in Louisiana? This is ridiculous. Iowa, that's where you want to roll out your first commercial for president? Oh, I'm sorry, he's not running. It's just an exploratory committee. This action seems determined to destroy Louisiana's business climate, especially our tourism industry that brings in millions of dollars every year. Advocates and businesses, large and small businesses, all spoke out against this bill. It's not just the mom and pops we try to protect. It was Dow Chemical. It was IBM. The Convention and Visitors Bureau. You all have gotten all the messages. Ignored all of that purely for a national ambition. When is enough going to be enough around here? When is he going to roll up his sleeves and come to work and do the people's business that he asked to do? We didn't beg him to run for governor. He asked to run for governor, and he's still governor. He's still governor. Act like it. This action is going to be implemented, which is a complete disservice and disrespect to both bodies. And it will severely damage our competitiveness, but yet it's done anyway. He doesn't care about Louisiana's economy, nor does he care about the people that we represent.
And as a doctor, I can assure you there are only two genders.
You told Todd Starnes and Fox News that the response to the ad is a reflection of our culture.
It is.
What do you mean by that?
I mean, we are now in a culture where nobody stands up for what I consider to be right. Nobody takes those stands that could be a little controversial. We're so scared as a culture, I think, to not want to get into the headwinds of the society that we just don't say anything. Well, look, that's not what we're here to do. As the representative of the people and as your next governor, my job and what the taxpayer and the voters should expect and should demand is that they know what they're getting when they get me as their governor.